prepare for the benefit of Ms. Cummins the pre-sentence investigation report?
State has, Your Honor.
Yes, Your Honor.
I want to commend you folks on getting this matter resolved through mediation. Mediation is a good process. It's not always successful, but when it is, it bestows the benefit upon the defendant of being able to control her destiny, for lack of a better term, as opposed to what may happen if you proceed to trial. Nothing forces you to do it, but sometimes defendants like to determine the outcome of things, or at least know going in the door what's going to happen. So good job to all of you on that. So with that being said, Mr. Mosher, you had something you wanted to address with the court?
Yes, Your Honor. Prior to proceeding with sentencing, Your Honor, I'm requesting that the defendant undergo a UA. Based on my observations, the observations of law enforcement, and the observations of court personnel, I have reason to believe that the defendant is impaired or under the influence. She is currently subject to bond conditions to where she is not to consume illegal controlled substances or alcohol, and is subject to random UA, breath or blood tests. And based on that and the seriousness of these proceedings, I believe that my request for UA is reasonable.
Mr. Premier, what's your position on that?
Your Honor, I would object. My client is not under the influence of any illegal substances. She does take prescription medication. And so Judge, we would object at this time.
Well, I think the number one question I've got is, does your client actually take prescription medications? And if so, what are the side effects or contraindications?
Judge, she takes, it's like a non-narcotic, but it's for muscle relaxer.
Does she take all of those simultaneously, or are they staggered throughout the day?
This right here is an important legal moment. The judge is highlighting why mediation matters. It gives the defendant control instead of rolling the dice at trial. That's huge in criminal cases. Once you go to trial, outcomes are in the jury's hands. Quick question for you watching. Would you rather take a guaranteed deal or risk everything for a chance at acquittal? Drop your thoughts below.
Judge, she takes in the morning, and then the other one she takes at nighttime.
Mr. Mosher, what's the basis? What phenomena or symptoms have you observed that makes you think that a UA may be appropriate at this time?
Your Honor, the behaviors I'm seeing, I would associate with what I've observed previously, what law enforcement described to me as tweaking. And I can try to bring the officer in if you want to hear more from him, if that's the case, Your Honor.
I think the best way to handle that is we bring him in and we actually swear him in, and I'll allow you to ask your questions, and then I'll allow Ms. Premier to do that.
Yes, Your Honor. Your Honor, he got called for a EMS run on a life flight, but he believes there's other personnel to cover, so he said it'd take him about 5 minutes to get here.
Okay, if we can stand in recess at this point. I will caution you, Ms. Premier and Ms. Cummins, that the underlying conviction in this case is in fact for unlawful possession of a controlled substance, which is methamphetamine. And if in fact if the court orders that you were to submit to a UA, I'm going to be very, very concerned if in fact you test positive. And maybe think about that for a few minutes, and maybe.
I mean, I can tell you now that my client will likely test positive. I don't think that she's currently under the influence at this time. I've met with Ms. Cummins on numerous occasions, and I don't see a change in her behavior. That's my observation. Clearly, she does have a drug problem. That's why the plan was to get her on probation, get her into, you know, a drug and alcohol evaluation, and then hopefully get her into treatment. But I don't think, personally, I don't think that she's under the influence today.
Well, okay, she does have a bond condition then that requires her not to utilize drugs. Additionally, she's a convicted felon at this point. There's an admonition, I'm sure, from Judge Velez that she wasn't to utilize any substances between now and then, or not to engage in any unlawful activities. And the concern becomes, okay, you know, based on my fairly knowledgeable experience with this, there's a fairly short lifespan on the metabolism rate of the methamphetamine compound. So that would indicate most likely recent or heavy usage. So, Mr. Mosher, if we assume for a second that she's going to test positive and she does not challenge it any further, what would the state's position be?
Your Honor, I to some extent, I would leave that to the court. I'm just concerned if Ms. Cummins is impaired to, and this isn't the first time I've encountered this type of situation. I've taken the same approach. Given the seriousness of the situation, I'm concerned with going forward with sentencing if she is in fact test positive.
Okay. If that's the case, then I most likely will probably agree with the state. Because the last thing they'll really want is an individual who ostensibly is under the influence, particularly if her counsel has a good faith basis to believe that she will test positive, and we will continue the sentencing, and I will probably want her taken into custody until she presents with a clean urine sample, and then secondly, she'll be tested before her next sentencing hearing. So, why don't I go off the record? Ms. Premier, you go and talk to your client for a minute while we wait for the officer, and then you let me know what you want to do after having time to consult with your client.
Judge, I have consulted with her. Well, I'll talk to her and then I'll be back in a few minutes. That's fine.
All right, we'll stand in recess. Kansas, we've had a proffer. Well, let me get back on the record. Sorry. We are back on the record in State of Kansas versus Jennifer Shanae Cummins. The case number is 20 CR 17. Ms. Premier, I provided you an opportunity to confer with your client in confidence in regards to the state's request for a pre-sentencing UA. They've at least proffered a good faith basis, and you've at least proffered some disturbing facts. I left the ball in your court. The officer is now present and can provide the court with his testimony. Have you, after discussing with your client, how do you desire to proceed at this point?
Well, Judge, I mean, she will test positive. I don't know that the officer's testimony is needed today. I don't know if he's ever even met her previously, but Judge, I could make arrangements for her to get a drug and alcohol evaluation between now and her next sentencing. It is my understanding from my client that she has been, since her release from jail, she has had long periods of sobriety, and then would
Okay, things just got tense. The prosecutor just used the word tweaking, which is loaded language in court. This isn't a medical diagnosis, it's an observation, but it can carry serious weight. The judge immediately does the right thing here by saying, bring the officer in, swear him in. That's due process in action. Do you think the court should rely on observations alone or require hard evidence every time?
Lapse. She has had two recent deaths. A stepson of hers passed away in June, and then recently a friend of hers committed suicide. So that triggered her usage. She does believe that she can maintain sobriety and doesn't feel the need that she needs to be placed into custody in order to be sober. I will tell the court that she does have 2 young children, which she has custody of, and maintains the home for those children. So my concern is if she does go into custody, or if the court orders her into custody, that this could trigger a whole sync case and the kids being placed in DCF custody and just disrupting the whole family.
Where's the natural father at, or the significant other?
So the oldest child, her father is incarcerated somewhere, and then the youngest child, he lives in Wallace County and has weekend visitation.
Mr. Mosher, I'm willing to accept the proffer of Ms. Premier Chavez that her client will test positive for today's purposes. Is that adequate for your purposes, or do you still want the officer to testify?
Your Honor, I would tell you that in the recess, I told the officer what he would be expected to testify about. One of the things that he expressed his concern to me, that his greatest concern based on his observations was the fact that the defendant drove here and will be leaving here again in a vehicle, and he did not feel that that was a safe condition based on how she presented to him.
Ms. Premier, where does your client live?
She lives in Deerfield.
And how far from Tribune is that?
Like an hour and a half, hour and 15, I would say.
Where are the children at now?
I'm sorry?
Where are the children at now?
Oh, they took the bus home from school, and so they should be at that residence.
Who lives in the residence besides the defendant and the children?
Nobody else.
Are there family members in the town where she lives at?
No, Your Honor.
We've got a problem, obviously. Are you sure?
Judge, she could make, if the officer is concerned about her driving, Ms. Cummings could make arrangements for somebody to come pick her up and drive her back, and then they could possibly come and retrieve the car with someone else if the officer has concerns about her driving.
Well, I would think that Ms. Cummins would be concerned about her driving because the officer ostensibly has a good faith basis to issue yet another charge, and I'd be worried if I were her about having a potential another conviction. Mr. Mosher, I don't know what facilities are available up there or what programs are available. But if I order her to be taken into custody until she gives a clean UA, is there anything that can be done to ensure those kids are taken care of until she's released and can pass the UA? I don't want them left alone.
Yeah, I understand the court's concern, and I do not know because, Deerfield is Kearney County, I believe, and I'm not sure what's available there, Your Honor.
Well, I suppose an order for protective custody could be issued, but that would need to originate from the county where the children are at. Am I right on that?
Yes, Your Honor. I believe that is correct.
All right. I'm going to order that the defendant be taken into custody until she completes your analysis and is clean. I'm going to ask that the county attorney contact the Kearney County attorney and take the children into protective custody, and we'll let it fall out from there. I don't think we can jeopardize the safety of those children if mom is in a remission right now. That means those drugs may be prevalent in the house. It's certainly not a lifestyle those kids need to be exposed to. And then we're going to go ahead and reschedule the sentencing in this matter.
Yes, Your Honor.
Ms. Chavez, Mr. Mosher, how likely is it that you can get that accomplished, or what happens to those kids if, for example, you can't get hold of Mr. Gallegos?
I don't know. They're obviously, from my opinion, I guess they would be unsupervised, which is not a good situation, Your Honor.
As an alternative, I think DCF could be contacted and they could take those kids into protective custody as well.
Judge, my client believes that if if she were to reach out to the youngest child's father, that he could possibly care for the children instead of placing them into custody until she's released.
Is this something that can be accomplished fairly quickly?
Yes.
All right, I can, next 5 minutes.
Yeah, can we take a recess to find out if that can be accomplished, Your Honor?
That's what I was going to suggest. All right, we're going to stand in recess. In all likelihood, the defendant would test positive for methamphetamine on this date, the date of her sentencing. So with that being said, that brief overview, Ms. Premier, what's your client's position at this point?
Judge, I wanted to let you know I spoke with Retta Underwood, who is the maternal aunt of Ms. Cummings. She's actually on the line. I just had her hold on so that if you wanted to hear from her personally, you could. She is willing to go over to the house and pick the girls up. They're out of school for the remainder of the day and the remainder of the weekend. So she's able to care for them.
Okay, very good. So, Ms. Pereira, I don't need to speak to her. I mean, I'm going to rely upon what you've advised me. The biggest thing I wanted to make sure is that those children were protected and they're not sitting in a home without somebody taking care of them. And if you feel comfortable with those representations, then at some point we have to rely upon that. I would rather they were in the custody of a family member as opposed to being taken into foster care, for example, whatever the situation may be. So with that being said, we are not going to have the sentencing on this date. We're going to take Ms. Cummins into custody, and she's going to remain there until she tests positive for a urinalysis.
You mean negative?
I mean negative for a UA. The other concern that I've got is, does that satisfy the inquiry of the state, or is the state looking to revoke her bond in its entirety, or will that suffice for now?
That will suffice for now, Your Honor.
The other thing, I'm going to add some additional conditions of your bond here, and that's going to be that you are going to have to undergo at your expense every Monday and Thursday until the date of your sentencing a urinalysis, and it needs to be at somebody reputable. I know in Finney County, Excelicare will do theirs, and some of the trucking companies will do those, and they're certified. If you don't do it, you got a big problem. So that's Monday and Thursday. I want those results submitted to Mr. Mosher's office no later than 5 o'clock on those 2 days. Finally, be prepared at your next sentencing hearing. You're going to be subjected to a UA before we ever commence with the actual sentencing itself. Are there any other conditions that the state would request at this time?
No, Your Honor.
All right, so the next thing we're going to do is we're going to look for a new sentencing date. I would probably encourage you, Ms. Premier, just like you indicated earlier, that between now and the next sentencing date, that you obtain some type of drug evaluation if possible. If not, it'll be ordered pursuant to the PSI. If your client truly has the problem she does, says she does, it may be beneficial to even assist.
This is where the stakes explode. The case is no longer just about sentencing. It's now about child safety. Courts are legally required to prioritize minors, even when it means making a heartbreaking decision. Notice how the judge balances compassion with responsibility here. Final question for you. Did the judge make the right call by ordering custody and protective placement, or was there a better alternative? Let me know your take.
Court services, or community corrections, excuse me.
Your Honor, just not to interrupt, but I still have Ms. Underwood on the line. Can I let her go so she's not just on hold?
That's fine, and you can authorize her to go and pick those children up now.
Ms. Underwood, can you go get the children?
Yes.
Okay, so
They need to be with family.
okay, so if you wouldn't mind going to get them, I'm gonna let you off the line, okay?
Okay.
Thank you. Okay.
All right, so for a sentencing hearing, I'm looking at, well, we can go to October, but I'm concerned if your client's problem is as bad as you've indicated, that she's going to have a significant relapse, there's going to be bigger problems. That's what I'm concerned about. On the 5th of September, I'm available.
That's Labor Day, Your Honor.
So I'm not
That's-
good.
10 Mountain, that'd be 11 Central.
All right, I always get confused on this. If I need to be there by 10 your time, what time do I need to leave here?
10.
You would need to leave there
At
9:30 Central Time.
Okay. So, I feel like I'm in a MASH episode. We're gonna have the sentencing hearing at 10 o'clock a.m. Mountain Time. All parties will appear in person. That's on the 11th of October. And I'm gonna leave at 9:30 to be there by 10,
Correct.
which was days ago yesterday, so. All right, so in the interim, Ms. Cummins, you got your marching orders, so unfortunately, you're gonna have to do those UAs, and they're not cheap on Monday and Thursday of each week. You kind of brought this on yourself, and I'm sorry you gotta incur those expenses, but it's better than the alternative, don't you think?
Yes, very much so.
Okay,
And those need to be faxed or emailed to my office by 5 p.m. on the day of the test, correct, Your Honor?
that's correct. It has to be from a reputable or certified individual testing agency. So for example, I had a case one time where domestic matter, but the husband was utilizing heroin and meth, and the judge ordered him to submit to a UA. Well, he took a video of himself taking a pee and submitted that to myself and the court. No, that doesn't work. Then he tried a home kit remedy. No, that doesn't work. I want it from an agency because he was manipulating it. So that's why I want it to be from somebody reliable. All right. I would impose a reporting requirement, but I don't know if Kearney County would do that, and having a report by phone to the Greeley County Sheriff's Office seems like kind of a waste of time. So the original conditions of your bond are reimposed. You've got your UA requirements that are imposed on you, and I think you got more at stake the next time around if it happens again, because then your kids are going to be brought into this in all likelihood. So have I made myself clear today on what's expected of you, Ms. Cummins?
Yes, Your Honor.
All right. Is there anything else we need to put on the record for today's purposes?
Judge, I just have a few questions. She's gonna stay in custody until she tests negative. How often are they gonna test her?
I don't know. That's not my issue. I think they're going to test her as often as they need to until they get a clean sample. So perhaps the best thing she would be to do is to say the last time that she used, and they calculate it out from there, and we come up with a reasonable time.
I just wanted to make sure that she's just not, they don't just leave her in there.
Well, no, I think law enforcement has a good faith obligation. Mr. Mosher's going to make sure that she's submitting to a UA at least on a regular basis, maybe once a day or whatever until she tests clean. But I don't think they're just going to leave her there. But obviously, if she just used earlier today, you got to wait about 24 hours for it to metabolize anyways. So in all likelihood, they'll start tomorrow.
She will be tested daily, Your Honor.
Okay, thanks. And then, Your Honor, you stated earlier that she can get testing done in Deerfield or Garden City. Did you name some places? 'Cause I'm not familiar with where that she can.
One place, and that was called Excelicare. It's a physical therapy place, and they also do testing there. And they are located next to the DCF building in Garden City, over there by the Bonanza restaurant. There's a trucking company in town there's a testing company in town that does it for truckers, but I don't recall what that's called.
Okay, thank you.
If you Google it, I think she can probably find it, but it's got to be certified.
Okay. Thank you. I have nothing else.
All right, with that being said, then we'll stand in recess. Ms. Cummins, I wish you the best of luck. I really don't like to have to do these things to you, particularly when there's kids involved, but you got to play by the game, okay?
I understand. That probably helped me a little bit. So.
All right, thank you very much, and we'll stand, anything else the state wants on the record at this point?
Nothing further from the state, Your Honor.
All right, we'll stand in recess until our next hearing. Thank you so much.